please you, my lords. I appear in this matter with Mr. Venkatasan and Mr. Paul for the appellants, and my learned friends Mr. Pillow KC, Mr. Davis KC, and Mr. Mukherjee appear for the respondents. Before I begin, can I just apologise to the court for the late sidelining of your lordship's authorities about this. I'm sorry that happened.
Yes, well, thank you for the apology.
Now, as your lordships will be aware, this appeal, for which the learned judge herself gave permission, raises important questions of law concerning the coherence and effectiveness of the UK sanctions regime. If somebody is sanctioned by the Secretary of State, it is generally because they are terrorists or persons who have committed or supported other serious wrongdoing. But if the learned judge's interpretation of the sanctions regime is correct, it would be open to such persons to use the English courts to obtain money judgments, which they could then enforce in a country in which they are not sanctioned. My lords, if that is really what the UK sanctions regime properly analysed permits, then so be it. But it is, we would respectfully suggest, a stark conclusion that requires careful scrutiny. Subject to your lordships, I propose to divide my submission into 5 broad topics. First, I propose to deal with certain points concerning principles of statutory interpretation, and in particular, Lord Diplock's speech in the DuPont case. All of the points I'm going to raise in that regard are material to the disposition of this case. Secondly, and against the background of the points about interpretation, I propose to address your lordships on the question as to whether it would be lawful under the UK sanctions regime to enter judgment on the causes of action advanced by the claimants. That is, as your lordships will be aware, ground 1 of our appeal. Third, I will deal with whether Ofsted, the regulator, has power to authorise the claimants to do various things, and in particular to obtain a judgment, to pay costs, to provide security, or to pay damages, or indeed to receive a payment pursuant to a costs order. And as your lordships will be aware, we submit that Ofsted does not have any such power. And that is, of course, the issues raised by grounds 2 to 4 and ground 7. And fourth, I propose to address your lordships as to why we say that a stay of these proceedings and the discharge of the undertakings is the appropriate response to these consequences of the sanction regime. Finally, I propose to deal with what has been called the control issue, namely whether NBT, the second claimant, is owned or controlled, within the meaning of the Act and the Statute, by President Vladimir Putin or Miss Elvira Nabiullina, the government of the Russian Central Bank, and therefore subject to the same asset freeze as the first claimant's Bank of Crete, and that's ground 5. Can I then move on to the first of my 5 topics, which concerns principles of statutory interpretation? And there are, my lords, 3 particular issues relating to the principles of statutory interpretation that loom large in this case. The first, my lords, is the common law principle of legality. And that is an issue that I will deal with in some detail later on in my submissions, but I mention it now only to note, as your lordships will already have done, that there is a very lively dispute between the parties about its application in the present circumstances. The second point of statutory interpretation concerns the significance of the language used by Parliament in construing the 2018 Act and the regulations. And I should begin by making it very clear, my lords, that it is certainly not our case that the language falls to be construed in isolation, which is something of a straw man set up by my learned friends in their skeleton. Nor do we suggest anywhere, nor do we contend, that the context and purpose of a legislation are irrelevant when construing that legislation. But my lords, it certainly is our case that the language is the primary source of Parliament's intention, and that it matters. Now, Your Lordships will appreciate, that is not really a point which it should be even necessary to make, still less for which it should be necessary to cite authority. But in view of the way in which the learned judge has approached some of the issues, and in view of some of the arguments made by my learned friends, I wonder if I can very quickly just show your Lordships one passage from Benyon, which conveniently quotes from the key authorities. Can I invite your Lordships to go to paragraph 11.1 in Benyon? Your Lordships will have that at AB, volume 7, tab 110, page 5013. So volume 7, tab 110, page 5013.
Sorry, volume 17, perhaps. It's not volume 7, I don't think. It's still. It's tab 110, but it's not volume 7.
Can your Lordships just indicate to me how many authorities panels you have?
Well, that's a very interesting question.
I think it's 18.
18.
17 plus a supplementary.
I have 7, and my notes are done by reference to 7. So what I'm going to do, I don't know whether it's clear from
Tab
the
110.
Tab 110.
If you give us tab numbers.
I'll give you tab numbers and page numbers.
We've got it.
Okay, I apologise for that.
Go on. Paragraph 11.1.
Paragraph 11.1. So just reading 11.1, summary of approach to interpretation. The primary indication of legislative intention is the legislative text read in context and having regard to its purpose. And then I'm not going to bother with 2 and 3. Then comment, as stated in Code 10.9, the legal meaning of an enactment is the meaning that conveys the legislative intention. The legislative intention is the meaning attributed to the legislature in respect of the words used. So the interpreter's objective when interpreting an enactment is to determine the true meaning of the words used by the legislature. This is a simple thought with profound consequences. The interpreter must focus on the legislative text, that is to say, on the words used by the legislature, and should view the guides to legislative intention described in this book as aids to determining the meaning as intended by those words. And just again, under that, the importance of the text. The text is the starting point and the center of the interpreter's attention from then on. After all, it is the text that is being construed. So, for example, in R&A, Lord Steyn said, it is a general principle of the interpretation of legal instruments that the text is the primary source of interpretation, other sources are subordinate to them. In Jackson and Attorney General, Lord Bingham said, the Attorney General invites the House to focus on the language of the 1911 Act, and in this he is right, since a careful study of the statutory language read in its statutory and historical context with the benefit of permissible aids to interpretation is the essential first step in any exercise of statutory interpretation. I'm just going to drop down to the quote from Lord Diplock. As Lord Diplock said in Black Clawson, the acceptance of the rule of law as a constitutional principle requires that a citizen, before committing himself to any course of action, should be able to know in advance what are the legal consequences that will flow from it. Where those consequences are regulated by a statute, the source of that knowledge is what the statute says. In construing it, the court must give effect to what the words of the statute would be reasonably understood to mean by those its conduct it regulates. Now, none of that is surprising to your Lordship. It states what we all know. But as I say, it is worth bearing that in mind as one goes through the arguments. Can I also just give your Lordships a recent authority which says the same thing? It's O against Home Secretary in the judgment of Lord Hodge, paragraph 29. I'm not going to give you the volume number. It's tab 75, page 4184. Now, as I shall come on to develop, my lords, we submit that the language of the key phrases in the 2018 Act and the 2019 regulations is or should be the primary source for determining the meaning of those phrases. And we also submit that when regard is had to the language, it becomes clear that the conclusion arrived at by the learned judge was wrong. My lords, the third point of statutory interpretation, which I wish to touch on at this stage, concerns the principle in DuPont Steels, to which, again, we respectfully submit the learned judge failed to pay sufficient regard. As your Lordships will be aware, that principle is concerned with the relevance of the facts of an individual case to the exercise of statutory interpretation. It makes a broad distinction between interpretation of a statute and application of the statute. Can I, for this purpose, just show your Lordship certain passages in the DuPont Authority itself? Tab 40, page 2979.
Yep.
Now, as your lordships may recall, this case arose out of a wage dispute in the early 1980s between the British Steel Corporation and its workers. The union called the strike at BSC, which failed to achieve the desired objective, and the union then called a further strike to include steel workers employed in the private sector as well, even though the private sector workers were not in dispute with their employers. Now, it was commonly accepted that this wider strike would have disastrous consequences for the British steel industry, and so the private sector employers applied for an interim injunction to stop the strike. Their ability to obtain interim relief depended upon whether the defendants would have any good defence to the claim, which in turn depended upon the application of a provision, Section 13(1) of the Trade Union and Labour Relations Act 1974, which provided immunity for any act, and this was the language of the statute, done by a person in furtherance of a trade dispute. That section had been interpreted by the House of Lords in an earlier case, also in 1980s, that's the Express Newspapers and McShane case,
Yep.
the lordships may recall that, as involving a purely subjective test, which meant that if the doer of the act honestly believed that it was in furtherance of a trade dispute, then it was in furtherance of a trade dispute, and the immunity was available. The courts in DuPont then had to grapple with this conclusion, which, as I say, it was accepted all round, produced a disastrous outcome for the British steel industry. And my lords, there are three passages in the speech of Lord Diplock that I wanted to show you, lordship. The first is at bundle page 2993, beginning at H, pick it up there, just goes over the page to A. That conclusion as to the meaning of the words that have been used by successive parliaments since the Trade Disputes Act 1906 to describe acts for which the doer is entitled to immunity from the law of tort over an area that has been much extended by the Acts of 74 and 76 is, as I pointed out in the McShane case, one which is intrinsically repugnant to anyone who has spent his life in the practice of the law or the administration of justice. Sharing those instincts, it was a conclusion that I myself reached with considerable reluctance, for given the existence of a trade dispute, it involves granting to trade unions a power which has no other limits than their own self-restraint to inflict by means which are contrary to the general law untold harm to industrial enterprises unconcerned with a particular dispute, to the employers of such enterprises, to members of the public and to the nation itself, so long as those in whom the control of the trade union is vested honestly believe that to do so may assist it, albeit in a minor way, in achieving its objectives in the dispute. And then just picking up the next paragraph, page 2995 at A, public acts of Parliament, if your lordships have that, public acts of Parliament are general in their application. They govern all cases falling within categories of which the definitions are to be found in the wording of the statutes. So in relation to section 13(1) of the Acts of 1974 and 76, for a judge who is always caught dealing with an individual case, to pose himself the question, can Parliament really have intended that the acts that were done in this particular case should have the benefit of immunity, is to risk straying beyond his constitutional role as an interpreter of the enacted law and assuming a power to decide at his own discretion whether or not to apply the general law to the particular facts of the case. The legitimate questions for a judge in his role as interpreter of the enacted law are: how has Parliament, by the words that it has used in the statute to express its intention, defined the category of acts that are entitled to the immunity? Do the acts done in this particular case fall within this particular description? If I can invite your lordships next to go to page 299, 2 and then 3 nines, and just picking this up at 2999.
Yeah.
Just picking it up at E, Lord Diplock here begins to identify the only argument that counsel for the employees in that case felt able to advance in support of the Court of Appeal's conclusion, which he articulates beginning at E. He says this: I do not, however, find the argument easy to formulate with precision. It starts with a question in a form which I've suggested presents the court with an insidious temptation to cross the boundary between interpretation and legislation. Can Parliament, in passing the Acts of 1974 and 76, have intended the immunity conferred by it to extend to acts the object of which was to coerce governments by the infliction of great damage on an innocent public? Parliament may not have expected, when it passed the Acts of 1974 and 76, that trade union leadership would use the immunity granted to them by Section 13(1) in such a way as to produce consequences so injurious to the nation. But if there is some legal limit upon the immunities under the existing legislation, it must be found as a matter of construction of the simple words to be found in the section. And then he identifies the section. Now, my lords, we respectfully submit that DuPont Steels is authority for three propositions which we say are relevant to this appeal. The first is that there is a distinction between the interpretation of legislation and its application. The second is that the task of interpretation is concerned with identifying the meaning of the, to use Lord Diplock's expression, categories defined or described in the legislation. For example, if legislation says no person shall drive an automobile after sunset, the categories, to use Lord Diplock's terminology, are person, drive, automobile, and sunset. And the task of interpretation is concerned with, and only concerned with, identifying the meaning of those categories, taking into account, of course, the context and purpose of the legislation. Then once the meaning of those categories has been identified, what remains is the application of the legislation. That is whatever happened in the particular case before the court within the categories or not. This last stage is not a question of interpretation, but rather of application. And my lords, what Parliament intended is at this stage irrelevant. Now, my lords, in seeking to illustrate what Lord Diplock meant when he referred to the categories used by Parliament, I've given your lordship a simple example of a statutory provision. But a good example of this is actually provided by Regulation 12 of the 2019 regulations. Now, we will need to look at that more closely in due course, but it may just be worth turning it up at this stage. It is at volume 2, no, I'll leave that, tab 16, page 918. Tab 16, page 918. Tab 16, page 918. Your lordships have Regulation 12 at page 918. Just looking at Regulation 12, the key categories, as your lordships see, so it says a person must not make funds available, directly or indirectly, to a designated person if P knows or has reasonable cause to suspect that P is making the funds so available. So the categories are, first, a person, secondly, make available, third, funds, and fourth, designated person. And as we respectfully submit, the task of interpretation is concerned with identifying the meaning of those words, obviously in context. And having interpreted those words, one then asks, is the relevant act in a particular case before the court, which may be a bank transfer, or indeed the entry of judgment, or something else within those categories. But again, as explained by Lord Diplock, at the second stage, Parliament's intention is irrelevant. The third proposition for which we submit to Port Steels is authority is this. The court can, of course, have regard to the consequences of rival interpretations in order to decide which interpretation is correct. Contrary to what my learned friends suggest, at, for example, paragraph 19.3 of their skeleton, it forms no part at all of our case that the consequences are irrelevant. But what my learned friends, with respect, themselves overlook is that the consequences are only relevant to the exercise of statutory interpretation, and only for the purpose of identifying some alternative construction that would avoid those consequences. And my lords, if the consequence of a particular interpretation are surprising, the court can look again at the language and ask itself, is there an alternative meaning of the words that avoids that consequence? If there is, and if it's appropriate to adopt that meaning, the court can do so. But what, with respect, the court cannot do, and what Lord Diplock explained is constitutionally improper, is to say that because Parliament cannot have intended a particular consequence, the legislation does not apply to that consequence, without explaining what alternative meaning of the words used can exclude that consequence while including others. And my lords, this is, we would respectfully submit, one of the main problems that run through both the learned judge's judgment and my learned friend's skeleton. And I say that, my lords, because whilst it is very clear from both documents what they say the 2018 Act does not mean, it is, with respect, not at all clear what they say it does mean. Or to be more precise, what alternative construction of the key statutory phrases would catch certain things which they accept are caught, but exclude the things they say should not be caught. And that is all I wanted to say about the DuPont Steels principle at this stage. I'll come back to it when I go through the learned judge's judgment. Can I then turn to the second of my 5 categories, which is whether the entry of judgment on the causes of action advanced by the claimants would be lawful. And it's fair to say I'm going to be taking most of my time on this particular ground. As your lordships know, we submit that entering judgment would be unlawful because it is an infringement of one or both of regulations 11 and 12 of the 2019 regulations. And my lords, whether this is right or not turns primarily on 3 questions. We've identified them at paragraph 20 of our skeleton argument, CB tab 4, page 41. But if I identify for your lordships those questions now, the first is, do the causes of action advanced by the claimants constitute funds or economic resources within the meaning of the statute? That's question 1. Do the causes of action advanced by the claimants constitute funds or economic resources? Secondly, if judgment is entered on those causes of action, would the judgment debt constitute funds or economic resources within the meaning of those expressions in the statute? So if judgment is entered on those causes of action, would the judgment debt constitute funds or economic resources? And then the third question is, does the act of entering judgment amount either to making available funds, contrary to Regulation 12, or a dealing in funds or economic resources, contrary to Regulation 11? Does the act of entering judgment amount either to making available funds, contrary to Regulation 12, or a dealing in funds or economic resources, contrary to Regulation 11? My lords, I'm going to address those 3 questions in turn, And having done so, I'm then going to turn to deal with a number of other matters arise out of my learned friend's submission and the learned judge's judgment to consider whether they make a difference to that answer. Just to identify what those points are in case your Lordship has them in mind. First, the European backdrop, which is certainly relevant. Secondly, the common law principle of legality. Third, Article 6 of the European Convention on Human Rights, on which my learned friends rely in their respondent's notice. Fourth, whether the court is a person for purposes of these regulations. And finally, certain workarounds, if I can call them that, identified by my learned friends, again in their respondent's notice, if the court decides that the entry of judgment is unlawful. But in my respectful submission, the place to start is by looking at the regulation itself. With those three questions in mind. So, my lords, the first question, do the causes of action pursued by the claimants, the first two actually, or any judgment debts they may obtain of these causes of action, constitute funds or economic resources, as those expressions are defined by the 2018 Act? The Lordships will find the expressions funds and economic resources defined in section 60 of the 2018 Act. If I can invite you to go to that, it's at tab 11. At page 816. Can I invite your Lordships, if you would, happy to read it, but can I invite your Lordships to read yourself section 60, subparagraph 1 and subparagraph 2? My lords, can I make two observations about the definitions of funds and economic resources? The first observation is this: as your Lordships see, they capture and are intended to capture between them every conceivable asset of whatever type or nature. And that is why the definition of economic resources is framed, as your Lordship see in subparagraph 2, in a way that catches any asset not already caught by the definition of funds. So, economic resources means asset of every kind, whether tangible or intangible, movable or immovable, which are not funds but can be used to obtain funds, which are goods or services. My lords, authority for the proposition that I have identified is given in, if I can just identify the authority, the case of Ahmed, paragraph 4, it's in Lord Hope's judgment, tab 21, page 2183. Second authority, it's a CJEU authority, but that will be relevant for reasons your Lordship will understand, which I'll come on to explain. Case of E&E, paragraph 69, tab 41, sorry, E and F, paragraph 69, tab 41, page 3020. As I say, my lords, I don't understand this to be controversial between the parties, that it is intended to capture any asset not already caught by the definition of funds. That's the first observation. The second observation is that, as recorded in the judgment itself, the claimants belatedly actually conceded below, and the learned judge held that judgment debts do constitute funds and that causes of action for damages constitute economic resources. And perhaps I can just show that to your Lordship. This bundle reference will work. It's core bundle, tab 8, page 172, paragraph 120 to 122 of the judgment. I'll just show that to your Lordships. So core bundle, tab 8, page 172. Paragraph 120 to 122. Just picking this up at the top of that page. Lordships have it. Ultimately, the claimants conceded that a cause of action could be an economic resource, essentially on the narrow basis that it could be used to obtain funds or financial assets and goods and services, for example, via assignment of a cause of action for money. That leaves the question of the status of a judgment debt. Here the oral argument started with a non-engagement by the claimants. However, in the face of the facts that in JSC and Taruta, the parties accepted that the judgment debt obtained by VTB for $29 million constituted funds within the meaning of section 60, subparagraph 1. Mr. Justice Jack evidently thought that the concession was rightly made. And judgment debts are assets similar in nature to the type of assets classified as funds. For example, debt and debt obligations in section 61. It is hard to see how a judgment debt is less a debt than a contractual debt. It represents an obligation owed by the judgment debtor to the judgment creditor to pay the sum of money awarded by the court. The claimants ultimately conceded that a judgment debt does fall within the wording of the Act as a fund. I would therefore conclude, in line with the claimant's concessions, that a judgment debt is on its face a fund under section 60, subparagraph 1 of the 2018 Act, and hence capable of being caught by both regulations 11 and 12, but a cause of action is an economic resource only. My Lords, in view of that concession, which we respectfully submit was correctly made, the only dispute that arises on this part of the appeal relating to the expression funds and economic resources and what they cover is whether causes of action also constitute funds rather than merely economic resources. And my Lord, that is not a point which may matter in the end, but we do respectfully submit that contrary to what the learned judge held, the cause of action is a fund and not just an economic resource. I'm not going to deal with that now. I'm going to deal with it at the point where it may matter, so that your Lordship sees the point in context. But for present purposes, your Lordships can proceed on the basis that it is common ground, that judgment debts are funds and causes of action are at least economic resources. On that footing, can I turn to the next question that arises, which is perhaps at the heart of this appeal, and that question is this. If, as is not in dispute, judgment debts constitute funds, would the entry of judgment for the claimants infringe Regulation 12? Now, as your Lordships know, we submit, respectfully, that it would. Can I just give your Lordships a reference to where we deal with this question in our skeleton? I'm not inviting you to turn it up, but it may help. We deal with this at paragraph 27 and following. That is core tab 4, page 43. My Lords, can I begin on this issue by asking your Lordship to go back to Regulation 12, tab 16, page 918. So 12.1, I've read that to your Lordship. A person must not make funds available directly or indirectly to a designated person if P knows of his reasonable cause to suspect P is making funds so available. Now there is an issue, as your Lordships know, as to whether a court is a person for the purpose of this regulation, and that is something I'm going to have to spend time on. I'm going to come to that. Putting that to one side for the moment, not because it's unimportant, it's important, but assuming for the moment that Regulation 12 does indeed apply to the court, the question that I need to address at this stage is whether the act of entering judgment would amount to making available funds. Because if it would, then again, subject to the question whether this applies to the court as much as to everyone funds. In light of my learned friend's concession and the learned judge's finding, this would mean that entering judgment for the claimants would indeed infringe the sanctions legislation. And we would respectfully submit, my lords, that it is on the face of it at least not easy to see how the act of entering judgment so as to put into the hands of the claimants a judgment debt could not amount to the making available of funds.
Would that be, do you say that so in relation to declaratory judgments as well as the money judgment? I understand the point in relation to money.
If it's a declaratory judgment, then it may have an effect on a cause of action.
Yeah.
But our simple point here is when it's an action for damages, which is a money judgment, then effectively you're putting money into the hands of the claimant. But your lordship's right to draw that distinction. Declaratory judgments become relevant and may be relevant to Regulation 11 for reasons I'll come on to explain. But your lordships can, no, your lordships won't put it aside because it's the sort of point that your lordship needs to do. It doesn't arise on this case. Now, my lords, we say it's not entirely easy to see why it wouldn't be the making available of funds, given that everyone accepts so far that the funds, that a judgment debt is a fund. The difficulty about this, my lords, is that the judgment is with respect unclear as to why the learned judge rejected our submission that the entry of judgment is indeed an infringement of Regulation 12. Now, your lordships will find the learned judge's analysis of this point, your lordship, as the judgment. It begins at paragraph 81, page 164. It's tab 8, page 164. Paragraph 81. The learned judge says this. This is a question which the defendants bear the burden of proof. The best way into this issue is to start by posing their central point, which is that the derogation from the fundamental right is here clearly authorized by the 2018 Act. In particular, the defendants submit that Section 3(1)A of the 2018 Act and Regulation 12 provides that a person must not make funds available to a designated person. The defendants submit that those words cannot, by any process resembling construction, be read as if it said, save that a judgment debt may be made available to a designated person. Now, your lordships will be aware that the judge rejected that submission, which was obviously one arising out of the language used in the provision. But as I shall show your lordships, nowhere does the learned judge identify some alternative interpretation of the language used in the regulation that would mean that giving a judgment in favour of the claimants would not involve making funds available to them within the meaning of the regulation. So if your lordships look at what the learned judge goes on to say in the paragraphs that follow, your lordships will see that the learned judge rejected our submission arising out of the language because, just looking at paragraphs 82 to 85, the learned judge thought it was not clear from the history of the sanctions regime that Parliament intended to prohibit the entry of judgments. That your lordship sees at paragraph 85. Taken together, these seem to provide a background to the regulations, wherein the entry of judgments is not precluded. And what your lordships will see from what is before that, that is all about the history of sanctions regime provisions. So that's the one ground which I need to deal with. And then at paragraph 94, page 167, the lordship sees this conclusion from the learned judge. I therefore conclude that the language does not provide the clear indication for which the defendants contend of an intention to move away from continuity in this respect and to bar entry of judgment. And my lord, that point about continuity, of course, is one that assumes that the entry of judgment was not prohibited in the pre-2018 regime. Effectively, what has happened here, if I can just step back, this used to all be dealt with by EU regulations and EU law. After Brexit, we had to change things, and we passed for the first time not just a regulation which tracks EU regulations, but our very own Act and our very own regulation. Both parties make the point when it suits them and pretend it doesn't exist when it doesn't, that there is no indication at all of an intention that there should not be continuity. In other words, all indications are that there was intended to be continuity. No one said everything is going to change. Brexit changes everything in this as well. And so both parties have, in a sense, fished in the pre-UK regulations, UK statutes world to see if they can find points which help them for the purpose of interpreting the post-EU world. And I'm not criticizing that at all. I wouldn't, because we do the same thing. But this is the basis upon which the learned judge came to the conclusion that she did, which is that we were wrong. Not by reference to any language at all, but by reference to conclusions that she arrived at looking at the pre-UK legislation, that's to say the EU regulations. With respect, in our respectful submission, she was wrong in her interpretation of the EU position, and I'll have to come on to that. That's what this continuity point is about, that she's making at paragraph 94. But my lords, even assuming that the learned judge was right about continuity and the points that she makes about the EU regulation, points that she found about the EU regulation, come on to that. There are, we respectfully submit, at least 4 difficulties with the conclusion that she arrives at paragraph 94. First, what your lordships see at paragraph 94 is the judge asking herself whether there was evidence that the draftsman wished to prohibit the entry of judgments, rather than tracking the language in DuPont, what the categories chosen by Parliament mean. And the categories here are person, funds, and making available. We respectfully submit this was a DuPont error. To be clear, I'm not suggesting for a moment that the learned judge was not entitled to look at context and everything else. I'm not suggesting for a moment that the learned judge was not entitled to, was bound to look at the consequences of our interpretation. And if our interpretation gave rise to an absurd outcome, the learned judge was quite properly identify that. But what then had to happen was the learned judge needed to identify an alternative meaning to give to the language used by the legislation. And with respect, that is what she did not do. Your lordships will not anywhere find the learned judge give any alternative meaning to the language used in Regulation 12, which captures the things that it is said should be captured, but excludes the entry of judgment. So that is our first concern, or our first difficulty. The second point we make is this, and it really follows on from the first point. We respectfully submit that the judge's conclusion that Regulation 12 does not prohibit the entry of judgment is, with respect, difficult if not impossible to reconcile with the language of Regulation 12. Again, my lords, assuming for the moment that the court is a person, I'll come to that, we respectfully submit that it is not at all easy to see on what linguistic basis it could be said that the entry of a judgment debt does not amount to making funds available to the designated person. Thirdly, the lordships will have observed that the learned judge, to be fair to her, did not actually say that our constructional interpretation of Regulation 12 was wrong. She said only, and I have in mind paragraph 94, but also the earlier paragraphs, that it wasn't clearly right. As one can see from paragraph 94. And the need for clarity came, as your lordships will appreciate, of course, from the principle of legality, which I'll have to come on to. But I mention this only because if we are right that the principle of legality doesn't apply, and as your lordships know, we say it doesn't apply here, that has particular significance for the analysis of Regulation 12, because the judge did not find that ordinary principles of statutory interpretation could produce the construction that she adopted. It also means that contrary to what the learned judge herself said at paragraph 138, it's at page 175, the principle of legality and her conclusion about that was essential to her decision, contrary to what she herself said. Because without it, there is with respect nothing, even on the learned judge's own analysis, which as your lordships know we don't accept, that explains why the entry of judgment is not unlawful under Regulation 12. And just to put that into ordinary speaking English, when your lordships, when we get to the principle of legality, your lordships will recall that where the principle of legality is involved, then any attempt to depart from the right of access to the court, the principle of legality, has to be clear from the language that is used. It doesn't have to be express language, but it has to be clear that Parliament intended that this should be a departure from that. So the learned judge, the language of clear comes from unison, I think Lord Reed's speech there. But there is, again, as I identified earlier, a very lively dispute as to whether the principle of legality applies here. If it doesn't apply, then your lordships will find no interpretation of Regulation 12 by the learned judge, which explains why we're wrong. So that's our third point. My lords, the fourth point we make is this. We say that it is notable that the learned judge's conclusion that the entry of judgment was not unlawful is, we submit, inconsistent with her own finding elsewhere in the judgment that it is unlawful to make a costs order in favour of a designated person. Just to say that point again, what the learned judge finds here is inconsistent with her own finding elsewhere in the judgment, where she concludes that it is unlawful to make a costs order in favour of a designated person. Can I on this just show your lordship in the judgment, paragraph 253 at page 196. The learned judge is dealing with a different part of the argument, indeed, I think it's ground 3 or ground 4. And just to pick up what she says at paragraph 253 at page 196, there was no real issue as to the first part of the argument. Making an order that the second defendant, absent a license, pays anything to the first claimant is making funds or economic resources available to or for the benefit of a designated person contrary to Regulation 12 to 15 of the regulations. So then later on, therefore, unless there is a licensing ground for authorising the payment under such an order, the court cannot make a favourable costs order, which encompasses the second claimant. So as your lordships see, the learned judge here appears to have drawn a distinction between costs orders in favour of designated persons and other judgment debts. Otherwise, it is difficult to see how she would come to the conclusions that she came to. And she has concluded that the former, that's to say costs orders, are prohibited under Regulation 12, but the latter, the entry of judgment for damages, for example, are not prohibited. And we respectfully submit that that is unlikely to be correct. A costs order, my lords, is as much a judgment debt as an award of damages. In both cases, the court orders the defendant to pay the claimant a sum of money, and it is that order which constitutes the judgment debt. And it is, we would respectfully suggest, my lords, unlikely that any rational sanctions regime would draw a distinction between costs orders and other judgment debts. It would either prohibit both or permit both, because distinguishing between the two does not promote any objective that a sanctions regime may want to pursue. Now, the lordships may have picked up that my learned friends say this was an error in the judgment, and that the learned judge here intended to refer to the enforcement of a costs order, not to its making. and that, I just give you a reference to that, that's footnote 13 of the skeleton. If your lordships look, however, we respectfully submit that that is difficult to see. If your lordships look at paragraph 251, subparagraph 1 on the previous page, page 195, your lordships see that the question that the learned judge posed before you get to 253, subparagraph 1, is the making of a costs order against the defendant in favour of the claimants, that is in favour of the designated person, itself making funds or economic resources available. So the learned judge was absolutely focused on the making of the costs order, and that is the question she answered at 253. So with respect to my learned friends, this does not appear to be an error. It is an inconsistency, but it is not an error in the learned judge's judgment. So, my lord, that is what we say about the reasons the learned judge gave for rejecting our case about Regulation 12. I should, before leaving this topic, just deal with two suggestions that my learned friends have made, I think for the first time in their skeleton argument in support of the learned judge's conclusions on this point. The first point my learned friends make involves the contention that entering judgment does not involve making funds available, because they say the judgment only declares the existence of a legal liability in respect of some prior wrong, such as a breach of contract or a tort. And that is the suggestion to be found in paragraph 50.1 of my learned friend's skeleton, core tab 5, page 108. My lords, that contention with respect, what it overlooks is their own concession, which is that the judgment debt itself constitutes funds, irrespective of the nature of the underlying cause of action. What constitutes funds is the order of the court, compelling the defendant to pay a sum of money by a certain date. That is what a judgment debt is. My lords, the learned friend's new contention, we respectfully submit, is inconsistent with their concession that a judgment debt of itself and independently of the underlying cause of action constitutes funds. It is also inconsistent with the bank's acknowledgement in a different context that it is the court order that gives rise to the judgment debt. I'm not going to take you to it, but that's in paragraph 68.2 of this skeleton. So the first point they make doesn't work. So far as concerns that second new point, if I can put it that way, this involves the contention that funds are made available to the claimant only when a judgment debt is paid or enforced or assigned or sold, and not when the judgment debt is entered. And again, for your lordship's notes, that's the point made by my learned friends at paragraph 50, 50.3 in their skeleton, tab 4, page 108. Point being, funds are made available to the claimant only when a judgment debt is paid or enforced or assigned or sold, and not when the judgment debt is entered. But again, my lord, this with respects, my lords, this with respects confuses a fund with consideration subsequently provided for a transfer of that fund. If something constitutes a fund, for example, shares in a company, and when those shares are provided to a designated person, funds are made available to the designated person within the meaning of Regulation 12. And that is so irrespective of what the designated person subsequently does with those shares. He may keep them, he may sell them, but the point is that he has them.
And just sticking around that for a moment, you say you can't distinguish between the creation of the fund and what happens to the fund. So taking your shares example, you would say that the issue of shares itself would be a making available of funds because you ended up with funds, namely shares. It doesn't matter that the funds didn't exist before the issue.
Indeed, we would say that. We give exactly that example, my lord. It doesn't matter that the funds didn't exist, and they didn't exist here. The issue creates the fund, and we're using funds in the way the regulation means it, in exactly the same way as when a judgment is entered, a judgment debt is created. It didn't exist before.
Well, if the suggestion is it's when the judgment debt is paid, it elides this
It does.
concept of making funds available with
It does.
issues such as execution.
It does, with respect. Maybe if two people met on the Clapham omnibus, as I use the word people deliberately, one may say to the other, you don't get funds until it's paid. Before that, you just have a judgment debt. But if you look at, we know, looking at the regulation and the Act, that funds cover assets of any kind.
Say that
Debt.
the width of the definition of funds in regulation, in section 60 of the Act,
Indeed.
makes it clear that what you describe as the ordinary man's concept of making funds available doesn't
Maybe
apply
wrong.
here.
Because it includes debt.
Yeah.
And a judgment debt is a debt.
Yeah.
Why is it on your submission that Regulation 12 doesn't extend to economic resources and is limited to funds?
Why? Because there's a separate provision which will come to under Regulation 11, which picks up dealing with economic
Right,
resources.
so as I understand the structure, dealing with as an activity covers both.
Exactly.
Making something available,
It covers funds.
i.e. creation, if I can put it loosely, only applies to funds, not to economic resources, although if you create, in terms of making available economic resources,
Yeah.
they can also then be converted into funds.
Regulation 14, my lord, maybe the answer to a question that your lordship's taken.
Thank you.
Tab 16, page 919. Thank you.
Oh, I see. I see. We've been focusing on Regulation 12.
We have, because those are the ones we
Because
rely
it's
on.
funds, but there's an equivalent one for
Exactly.
economic
We
resources.
don't have to rely on 14, we're relying on 12 instead.
Forgive
There
me,
is
I haven't.
Yeah, okay.
So, my lords, that's why we say the two new points that my learned friends identified don't work either. They don't really assist, in a sense, the learned judge. It's true to say
An
that
example of making economic resources available in the context of the present case would be, for example, an assignment of cause of action to a designated person.
that is probably caught by Regulation 11 anyway, but your lordship's right, it would be,
But if it isn't, it's caught by
it would be
14.
caught by 14.
Yeah.
We'll come back to that example because your lordship
Yeah.
puts your finger on a very important example, which is if you can't assign a cause of action, if you can't monetize a cause of action by assigning it, how come you can monetize it by, in a sense, use cashing it in for a judgment debt? One's allowed, in my learned friend's case, my learned friend accepts you can't assign a cause of action for money. But he doesn't accept that you can, that you're not allowed to use it to get a judgment debt. I'm going to come on to that when I get to Regulation 11. Regulation 11 is much more complicated, in my respectful submission, than Regulation 12. But your lordships will have in mind, I don't need Regulation 11 if I'm right on the Regulation 12. Regulation 11 may become important if I'm wrong on the court being a person. Because when we get to it, we also say that the learned friends are dealing in a cause of action, and that doesn't require anyone to find that the court is a person. It's simply not implicated in Regulation 11 if we are wrong on Regulation 12, and we need to get there. So, my lords, that is all I need to say, I think, at this stage about Regulation 12. Can I then turn to Regulation 11, unless your lordships have questions at this stage for Regulation 12? I'm going to have to come back to it, obviously, because I have to deal with the continuity point, and I have to deal with whether the court's a person, and principle of legality. But the basic structure of the argument is, if you look at it, in our respectful submission, it's difficult to see why, just looking at the language, why we're wrong.
Just going off a tangent, I suspect you're coming back to this anyway. You say this could matter in the context of whether the court is a person, and you point out that under Regulation 11, say, well, if the claimant asks for the judgment to be entered, that may be caught. Could that itself be caught under Regulation 12 on your construction? I mean, if a person asks the court to enter a judgment, might that be said to be making funds available?
My lord, I'm not sure that
Don't get
works. Well, I'd like to be able to say yes, obviously, but to be fair, it does say a person must not make funds available directly or indirectly. So the prohibition is on the person making the funds available. In this particular case, that person is the court making it available by giving the judgment, by entering judgment.
Yes, I see.
Because this is a fund which doesn't exist
Exactly.
before the
Exactly.
judgment.
If I can think of a reason to change my mind about this, your lordships will be the first to know, but at the moment I don't think I can go that far. So on to Regulation 11, if I may, for the moment. And for your lordships' note, we deal with this at paragraph 36 and following of our skeleton, page 45. I'm not inviting your lordship, I'm not going to go through that, but your lordship will have that. As I say, the issue as to the application of Regulation 11 arises on the assumption that for some reason the entry of judgment doesn't infringe Regulation 12, and we say it will nevertheless still infringe Regulation 11. And that is because, as we submit, the entry of judgment amounts, we say, to a prohibited dealing in the underlying cause of action, either by the claimants or by the court. If I can invite your lordships to go to Regulation 11, page 917 of tab 16. So a person must not deal with funds or economic resources owned, held, or controlled by a designated person if P knows or has reasonable cause to suspect that P is dealing with such funds or economic resources. And then subparagraph 2 says paragraph 1 is subject to part 7. A person who contravenes prohibition in paragraph 1 commits an offence. And then 4 and 5 are important. For the purposes of paragraph 1, a person deals with funds if the person uses, alters, moves, transfers, or allows access to the funds, deals with the funds in any other way that would result in any change in volume, amount, location, ownership, possession, character, or destination, or makes any other changes, including portfolio management, that would enable the use of the funds. So that is telling you, as your lordship see, how you deal with funds, and this is where it matters whether it's a fund or an economic resource, because the deal with, when it gets to economic resource in subparagraph 5, is much more confined. For the purposes of paragraph 1, a person deals with economic resources if the person A, exchanges the economic resources for funds, goods, or services, or B, uses the economic resources in exchange for funds, goods, or services. And then the brackets here may matter, whether by pledging them as security or otherwise. And then subparagraph 7, which will become relevant later. For the purpose of paragraph 1, funds or economic resources are to be treated as owned, held, or controlled by a designated person if they are owned, held, or controlled by a person who is owned by or controlled by a directly, indirectly designated person. For the avoidance of doubt, the reference in paragraph 1 to a designated person includes P if P is a designated person. Now, my lords, we make 2 points about Regulation 11. First, when a judgment is entered, at least a judgment for damages, the underlying causes of action cease to exist. It is extinguished. It is no more. And that is because it merges in the judgment. And that, of course, is the effect of the doctrine of merger. So, my lords, entering judgment for the claimants on the causes of action they advance would necessarily involve extinguishing those causes of action, which, if we are right that the causes of action constitute funds, and I'm going to start by proceeding on the basis that the learned judge was wrong about this, if we are right that the causes of action constitute funds, would mean you're extinguishing funds. And my lords, we would respectfully submit that extinguishing funds necessarily amounts to a dealing in those funds for the purposes of Regulation 11.4. So you're altering the funds under 11.4a by, in a sense, using them in destruction to get something else. And if not that, you're certainly changing the character of the funds by, instead of it being a cause of action, you now have a judgment date. Now, that's, in a sense, the first way in which we put the point. As your lordships will have picked up, the learned judge's answer to this was to reject it, and your lordships will see the learned judge's reasoning on this if your lordships go to paragraph 125 of the judgment, which is at page 172, and obviously behind tab 8. Paragraph 125. As to the latter argument, I do not consider that as a matter of construction, this answer can possibly hinge, as the argument plainly does, on the English law doctrine of merger, and the defendants themselves realistically acknowledge that that possibility would be surprising when it is not a concept which would be applicable in the European courts. If this were a good point, it would have to depend, and I'll come to that later, what the not on merger, but one of the defendants described as a broader and more fundamental reason that the cause of action are in a non-technical sense used. I'll come to the second argument later, but just focusing on the first argument and the learned judge, what the learned judge says at paragraph 125 in the first part. He says, as to this latter argument, I do not consider that as a matter of construction, its answer can possibly hinge on the English law doctrine of merger. Your lordship sees that the learned judge made the point that we had acknowledged, as we do now, that it might be thought surprising if the application of the sanctions regime were to vary according to the doctrine of merger, because that doctrine was obviously not designed with the sanctions regime in mind. But with respect, that is to miss the point. In particular, your lordship see that the learned judge in the first sentence of paragraph 125 used the words as a matter of construction. In fact, my lords, at this stage of the analysis, the only questions of construction, as distinct from application before the learned judge, were what the words funds, economic resources, and dealings meant in Regulation 12. All of those terms are defined. For example, as your lordship see, the meaning of the term dealing in funds is defined by 11.4a. And again, my lords, the meaning of those terms cannot vary according to whether the doctrine of merger exists or not. The doctrine of merger is only relevant to the application of Regulation 11, not to its construction. And in applying Regulation 11, one takes English law as one finds it. And if, because of the doctrine of merger, the entry of judgment would constitute a dealing in funds by extinguishing the underlying cause of action, with respect, that cannot be a reason to disapply Regulation 11 to that situation, which is in effect what the judge did in the guise of interpretation. That, we would respectfully suggest, involves making a DuPont error, confusing application and interpretation. If the existence of the doctrine of merger in some way undermines the application of Regulation 11, and if the legislature thinks that it shouldn't, then the solution is to change the legislation. But at this stage, your lordships are simply interpreting the legislation and applying it, and one takes English law, as I say, as one finds it.
So the interpretation here is the word uses and changes character, which are the two that you've identified. Although you've actually used the word extinguish, we don't, I think, find that in the regulation.
Well,
but you say it's using it and it's changing its character.
Indeed.
Although you made the point earlier that there's really no distinction in kind between a cause of action you can assign and a judgment that you can assign.
Yeah. But
But
you've changed
you
its
say
character.
that as a matter of
Well, you've
because
changed
of the
its
doctrine
value.
of merger, it changes character within the meaning of the
It certainly
regulation.
changes its value. because a cause of action, until you get a judgment debt, isn't worth the same as the judgment debt. You could assign it, but you're very unlikely to get the same value, for example, as the judgment debt itself is if you succeed. And you certainly change its character, because what you can't do is go to a foreign court and say, here's my cause of action, I want you to enforce this cause of action, but you can do that with a judgment debt. You've certainly done something to change it. And that's why we say, if it's a fund, then you have, you do come within subparagraph 4A and indeed B. And that would be the interpretation as opposed to, well, the application would be applying it to a cause of action and a judgment debt. Now,
Well, you say just the applicant, and your point about application, if a cause of action emerges in judgment, then you have used, I mean, on the hypothesis that the cause of action is funds, you've used the funds, or you have changed the character of the funds.
exactly that. That is exactly
It doesn't matter that that comes about by virtue of some doctrine of English law which
Indeed.
is not known to the European courts, not
Exactly.
because this is an English regulation.
Exactly. What matters is that happens. The exact mechanism that English law uses is neither here nor there. It happens as a matter of English law because of the doctrine of merger. That is how we think about what has happened. But with respect, it doesn't matter whether you called it anything. When we're giving it a fancy name.
Because in one sense, the doctrine of merger is, if you like, an accretion on, in addition to what's actually happened. Because what has happened, you say, is a change in the nature of the cause of action, change in the character of the cause of action. Because it's now a judgment debt.
Your Lordship is right. The doctrine of merger is simply trying to explain to lawyers and for lawyers what happens to the cause of action when you get a judgment.
Yeah.
But again, talking about the people on the Clapham Omnibus or the Europeans, it doesn't really matter what you call it or what legal doctrine you decide to label it as. You're effectively using your cause of action to get a judgment, a judgment debt. You're also altering the cause of action when it becomes a judgment.
But I think your overarching point is that even if we didn't have the doctrine of merger and the cause of action survived and you had both your cause of action and the judgment,
Exactly.
you would still be acquiring something which was different in character.
My Lord, yes, and that is our wider point. I think the learned judge preferred that point, and with respect, one can see why. It's a much simpler point in a way to grasp that.
Is that a convenient moment to take a
My Lord,
break for 5 minutes?
Or 2-year-old.
My lord, I dealt with the doctrine of merger. I was going to identify our second observation about the position if, in fact, the cause of action is funds. This doesn't, as I think my Lord Justice Popplewell and indeed the Chancellor make the point, this doesn't depend on the doctrine of merger at all. It's the point that the learned judge picked up on. Entering judgment involves, even in an entirely non-technical sense, using the cause of action. Just as a person may not be able to get a loan unless they give security in the form of their house or some other asset, a person cannot get a judgment unless they have a cause of action. In both cases, the thing that is used to get what is wanted, a house or a cause of action, may remain in existence after the thing that is wanted, a loan or a judgment debt, is obtained. So it doesn't have to be extinguished, it remains in existence. You just got what you wanted by using the other thing. It doesn't change the fact that the person had to use the thing, be it a house or a cause of action, in order to get that which they were seeking. And, my lords, that is sufficient.
Well, hang on a moment. The entry of judgment is done by the court. It's not done by anybody else. The other examples you're giving of people using things are not being done by the court, and we have to focus on whether. I'm leaning to one side whether the court is a person. If you're right that the court is a person, then you say, for the purposes of 11.4, the court, the person, has dealt with the funds by using them, by entering judgment.
Indeed.
But if you can't, as it were, elide that and then look at some other person other than the court.
With respect, I say both the claimants and the court are dealing.
What's the claimant doing that's
The
dealing?
claimant is using its cause of action
How?
by litigating on it before a court with a
So the whole of the litigation is a breach of Article 11.
well, it
regulation.
can't get a judgment without a cause of action. So it's using its judgment to get, using its cause, it can't get a judgment without its cause of action. So it's using the judgment, using the cause of action to get a judgment.
But I thought you conceded that the pursuit of the litigation per se was not a breach of the regulations.
I don't say it is a breach of the litigation. My case is that in order to get a judgment, you need to use the cause of action. If you don't have a cause of action, you cannot get a judgment. So the court will not enter judgment for the claimant unless the judgment has a cause of action, unless the claimant has a cause of action which is using in that litigation to get the judgment. That's what where it goes. That's
Can I just understand it? So the key words are uses the funds, are they? So
Yes.
uses the cause of action
for this particular one.
for this particular argument. So uses the cause of action to obtain the judgment. So which bit of the pursuit of the litigation is the using?
Inviting the court to enter judgment.
And why is that different from issuing the claim in the first place? Is that not an invitation to the court to proceed towards the entry of a judgment?
With respect, it's not using the cause of action in the way identified by the provision, because you are, what are you, simply by issuing a cause of action, let me put it differently. I can issue a claim without having a cause of action. But
Well,
I can't.
leaving that to one side, because that really is an extreme example. Most claims that are made in these courts, particularly in these courts, are claims where there's a cause of action. So the issue of the claim, so issue of a claim form in the business and property courts, based on a cause of action for breach of contract, for example. Is that using the funds?
I want to resist that argument. Can I? And I will answer that. Can I? Because we're in danger of eliding two of my arguments here, and I just want to be clear as to which one we're dealing with.
Right.
Because the first argument is that the court is doing that which it is not allowed to do, even for the purpose of regulation 11. Okay, and the court is using the cause of action in giving a judgment because it needs a cause of action to give a judgment. Or the court is dealing with the cause of action for these purposes of fund in a way which changes the value, character, etc.
You understand that.
Okay, so we're now on to, and if I'm right about that, then I don't have to worry about my other.
Yeah, we understand that as well.
So I'm doing it so that I understand what I'm doing.
They're
rather
not,
than you.
they're, sorry to interrupt, but they're not wholly, in my mind at least, divorced from one another. Because focusing just for the moment on the court as the relevant person. So when you talk about the court using the cause of action, it's not the court's cause of action, it's the party's cause of action. And so your definition of using necessarily involves saying the court is taking that and has to take that in order to create the judgment debt.
I accept that. Of course, I could put that argument about what the court is doing by reference to B rather than A. In other words, move away from using and saying it deals with it in a way which is changing its nature.
Because of the doctrine of merger.
Because of the doctrine of merger. Well, even moving away from the doctrine of merger, it is certainly dealing with the cause of action in a way that changes its character, because it's changing the value of the cause of action, if you like, by giving a judgment instead of it, or on the back of it. How?
A cause of action, in the sense we're talking about, must mean a valid cause of action, mustn't it?
Yes, certainly for that
So
purpose.
how do you change the value of a valid cause of action
Well,
by turning it into a judgment debt?
because I could have a valid cause of action, but unless and until it's a judgment debt, it cannot be worth the same as a judgment debt. There are different things I could do.
If the hypothesis is that it's a valid cause of
Well-
action, then surely its value is the same.
The fact is, you know with hindsight that it was valid.
Well, I know in the real world you do, but I'm using cause of action here in a slightly different sense, I think, from my lord was using it in. Not an averred cause of action, which you have the moment you issue a claim, but an actual cause of action. We're only concerned with a judgment debt, and you'll only get a judgment debt if, as it happens, you have a valid cause of action. Otherwise, it won't be turned into a judgment debt. Leave aside declarations.
Okay.
So if cause of action means an ex hypothesi valid cause of action, why are you changing its value?
Because value is what the market would pay for it. I'm not sure how you're supposed to, when you go and you say to someone, I have a valid cause of action, the trial's 2 years away, can I assign it? What will you give it to me by way of an assignment? They're very unlikely to pay you, one doesn't know, but the likelihood is they will not pay you what you would receive from
I understand. That's the difference between an asserted cause of action and a determined to be valid cause of action. But if the cause of action we're talking about is one which is ex hypothesi valid, is there any change in value?
So it's an ex.
Or is the analysis wrong that we're talking about an ex hypothesi valid?
I'm not sure that one should be talking about an ex hypothesi valid cause of action, because I'm not sure how you can have an ex hypothesi valid cause.
Because it's a cause of action that's sufficiently valid, using my lord's word, to be turned into a judgment by a court.
You could have a cause of action which is sufficiently valid so that it doesn't get struck out. That I understand. It's an ex hypothesi valid cause of action in that it has its content, its nature is such that it is sufficient to form the basis for proceeding to a court and asking the court to grant you enter judgment on it. But what I can't conceive of is a cause of action which on day one, in circumstances where the trial is on day 100, which to the market, if I can put it that way, if you're going to determine its value, has the same value to the market as the judgment debt itself would have.
Which is another way of saying an arguable but invalid cause of action is a fund.
No, because I might have a I might think I have a cause of action which is valid, and in the sense that your lordship means it. My lawyers may tell me it's valid, but your lordship, it's not that long ago your lordships were in practice, and you know that you could have what appears to be a completely valid cause of action where you lose for whatever reason. And because there's inherently an unpredictability.
But I think it does follow from your submission that an arguable cause of action, which turns out to be invalid, is itself a fund.
It must be a fund, and I'll come to the argument. It's certainly an economic resource, but I would respectfully submit it's a fund as well.
Just before you move on, does a claimant on your case breach regulation 11.4 before judgment is entered?
It may be that he does under 4B. I'm inclined to think not, but I'm just testing it by reference to the language. Because as I said 4B, but I'm not sure that works. Deals with the fund in any way that would result in a change. I think one needs the change before you can say that there has been a dealing.
But you rely on 4A.
I rely on 4A. Uses, alters, moves, or transfers, allows access to the funds. Our argument about 4A is that you use it to get the judgment debt. Now, I appreciate that's not answering your lordship's question. Your lordship wants to know, is it being used when I issue it? And we would respectfully submit that you are not using it by issuing it.
But you're not using it either in closing submissions.
You're not using it either in closing submissions. You're making the closing submissions because you have a cause of action which you wish to use to get a judgment debt.
So in the end,
you are using it.
what everything that you've done in the litigation is not using the funds. What is the use of the funds is the entry of the judgment, and that's not done by the litigant at all.
Except that the litigant has come before the court with the funds and asked the court to turn it into a judgment. And
I follow that, but that suggests that the whole pursuit of the litigation would be use of the funds.
No, this is a much more, I accept this is a much more difficult argument than the Regulation 12 argument. And it's because my learned friends give the example of what, at what stage are you using the funds and what stage are you not using the funds, or economic resources.
I had thought that your argument was quite carefully tailored to say that the relevant activity which constitutes the dealing for Regulation 11 purposes is the entry of the judgment, the entry of the money judgment, and not anything that precedes it.
That is what we say.
Is that right?
That is right.
Thank you.
Now, I think we'll be going over territory we've just been over. The learned judge rejected our wider way of putting the case at paragraph 126 of the judgment, which is at page 173 of the bundle. She says the bottom line here is that one can certainly read these provisions in this way. It is not, however, clear that one must do so. As I've indicated above, this argument does not work if, as I had been minded to conclude, a cause of action is not an economic resource at all. Nor, even on the basis that it is an economic resource, can it realistically be said that the court is itself dealing within the meaning of Regulation 11.5, exchanging or using, as the way in which this part of the argument was cast indicates. it follows that on the basis that a cause of action is taken to be an economic resource, it would not be caught by the regulation prohibition on dealing, making available. Now, just the first point we would make about this, and we have a number of points, is if your lordships look at the passage, the word realistically obviously doesn't change what with respect is an otherwise conclusory observation, but we submit that this reason in any event doesn't stand up to analysis. Assume first, my lords, that a cause of action is a fund rather than an economic resource. In that event, the value or character of the fund would change when judgment is entered, because if a claim succeeds, a cause of action with a judgment is worth more than a cause of action without. And equally, if the claim fails, the cause of action is worth less or worth nothing than it was before the court gave judgment dismissing the claim. So there must be a dealing in the fund within the meaning of Regulation 11.4, either by the claimants or the court. If, on the other hand, the cause of action constitutes an economic resource only, then we accept that the court is not dealing in the economic resources by entering into the judgment. Just to explain why we accept that, if your lordships look at 11.5, for the purposes of paragraph 1, a person deals with an economic resource if the person exchanges the economic resource for funds, goods, or services, uses the economic resources in exchange for. We say the court isn't caught by that because the court is not getting anything back. So if it's an economic resource, then we accept it's not within 11.5, if it's only an economic resource. But we say the claimants are dealing, even if it's an economic resource. If your lordships can go back to 11.5b, as your lordship sees, this provides that there is a dealing in an economic resource. The person uses it in exchange for funds, goods, or services. My lords, if the claimants obtain judgment for $850 million on the causes of actions they advance, they would, we say, have used those causes of action to obtain funds, namely in exchange for funds, the judgment debt. So there would, we say, be a dealing by the claimants. Now, your lordships may recall that the learned judge described this as a clever argument, but she rejected it. That was at paragraph 147 of the judgment. She rejected it on the basis, if we just look at it, if we go to page 176. Clever as the argument is, I'm not persuaded that this is correct, the correct reason for not pursuing this analysis.
Yeah.
That is because it is not the parties who would do anything active to enter the judgment. So the basis upon which the argument is rejected is that the claimant does not, as she put it, do anything active to enter the judgment. With respect to the learned judge, this conclusion is based on the assumption that Regulation 11.5b applies only if the person using the economic resource does something active in the final steps of the process by which funds are made available to him. But that, with respect, is not what Regulation 11.5b says. It says there is a dealing if economic resources are exchanged for funds, which of course they can be, even if the funds are received, at least as regards the final step of the process, passively. And in practice, that is, of course, what usually will happen. Lords, just to take another example, if I mortgage my house, the lender would, in the final stages of the process, transfer the money to my bank account. I don't do anything active at that final stage to get the money. My lords, it could not be suggested that I have not dealt in my house, which is an economic resource, as part of the process to obtain the funds, that is to say, the money. I have, in the words of Regulation 11.5b, used my house in exchange for funds, namely the money the lender gave me. The Lordships will see that in Regulation 11.5b, in the parenthesis, this is expressly identified as dealing. You should see that. Uses economic resources in exchange for funds, goods, services, whether by pledging them as security or otherwise. And so we respectfully submit that the active participation requirement in the final stages of the process introduced by the learned judge is unsound. So that was the judge's first reason for rejecting the broader way we put the point on Regulation 11. My lords, the judge's second reason for rejecting our submission about Regulation 11 concerned two authorities, Taruta and R&R, which she took to be supportive of her view that there is no dealing in the cause of action by entering judgment. Your Lordships can see that between paragraphs 127 and 129 of the judgment, page 173. Now, I wasn't going to take up time going through those, my lords, because the learned judge acknowledged that the observations she cited were either obiter or made without the benefit of any argument to the contrary. And the issue before your Lordships now, namely whether the entry of judgment amounts to a dealing in the underlying cause of action, was not an issue in either of those cases. So, in my respectful submission, your Lordships will not be assisted by them. The only thing I should say, my lords, is that the Taruta case, to which the learned judge referred at paragraph 127, was the subject of an appeal to the Court of Appeal in the Eastern Caribbean. And the appeal judgment handed down on the 25th of January 2023 came to our attention after the appeal skeletons were put in. I'm drawing this to your Lordship's attention so your Lordships have the up-to-date position. My learned friends don't cite that, but I ought in fairness to mention it, because the Court of Appeal, the Eastern Caribbean Court of Appeal, held that Mr. Justice Jack was entitled, notwithstanding the sanctions regime, to set aside the receivership order. So to that extent, the submission we made to the judge, and indeed to this court, recorded in paragraph 128 of the judgment, is no longer open to us. We made a submission on the back of what Mr. Justice Jack had said. We can't make that submission anymore. My lords, the learned judge's third reason for rejecting our Regulation 11 argument is at paragraph 130 of the judgment, so that's page 173. Have that. She says, greater weight is added to these points by the background which I have outlined above, yet further weight is added by the approach to licensing. The defendants note that there is neither an exemption for nor any power in OFSI to license the entry of judgment in favour of designated persons. That is true, but in paragraph 6 of Schedule 5, there is permission for OFSI to license the use of designated persons' frozen funds to satisfy a judicial decision. The fact that it refers specifically to decisions made before designation would seem to suggest quite strongly that the making of other judicial decisions is contemplated and permitted. It also carries some suggestion that there is no provision for licensing because it is unnecessary. Now, can I just identify for your Lordships what we say about that? I'm not going to develop this. We have set out our response to this in our skeleton. If I can just show your Lordship what we say there. Yeah. Paragraph 42 of our skeleton, page 48 of the core bundle. Paragraph 42, page 48, behind core bundle 4. The judge's third reason, if you have it, bottom of page 48, the judge's third reason was founded upon Schedule 5, paragraph 6 of the regulations, which permits OFSI to license the use of a designated person's frozen funds to satisfy a judicial decision. That provision is concerned with judgments against a designated person given before the date on which the person became a designated person. The judge's observation that the specific reference to pre-designation decisions would seem to suggest quite strongly that the making of other judicial decisions is contemplated and permitted. This is with respect to non sequitur because Schedule 5, Paragraph 6 is concerned with the satisfaction of judgments, not their entry. It does not carry any implication that entering judgment, whether pre or post designation, is permitted. 2, even if it did, it does not imply that post designation judgments are permitted because it is expressly confined to the satisfaction of pre-designation judgments. And 3, even if it could somehow indicate that post-designation judgments are permitted, it is concerned with judgments against, not judgments for, designated persons. My Lord, as I say, we respectfully submit that the learned judge's third reason in paragraph 130 is a non sequitur for the reasons we identify in our skeleton argument.
Can you just give me a page number for Schedule 5, Para 6?
I think it's 1256.
1256, thank you.
Yep. 1256, correct. Tab 16.
Sorry, Mr. Relennis, I just wanted to look at the actual provision. Just,
We're going to be spending some time on that.
yeah,
So page 1265, if your Lordship has that. So these are the licensing grounds that your Lordship sees. It's really B.
yeah.
Decision was made. 1256. The decision was made or established before the date on which the person became a designated person. So we say, with respect, that doesn't help. In fact, the reasons we'll come to it actually helps us put on the licensing grounds rather than here.
You say implementation or satisfaction actually just means satisfaction.
It means satisfaction. That's what we say, yeah. I'm not sure there's a dispute about that, but yes.
So why isn't implementation a judgment in favour of a designated party?
Because this is about the implementation of a judicial decision. It presupposes there is a judicial decision which you're implementing. And what we're arguing here is really about the creation of the judicial decision. This in a sense, happens a step later. It's putting into effect a judicial decision. Satisfaction, I apprehend, is about money. Implementation is about an order to do something. But both of them require that you first have the judicial decision.
Well, implementation might be enforcement, mightn't it?
Well, I don't mind if it is enforcement. But what it is the entry of the judgment.
It's a
In a way,
pre-existing judgment.
yeah. What we're arguing with respect is here about the entry of the judgment. Anything that happens thereafter, enforcement, satisfaction, is a step beyond the step we say the court is not allowed to take.
I mean, what you really say, I think I'm right in saying, is that this provision doesn't help the interpretation of the provisions we're currently considering.
Indeed.
Because this is dealing with, but really for two reasons. One is that it's dealing with judicial decisions made before the sanctions are imposed, which by definition we're not talking about. And secondly, it's about judicial decisions made against a designated person.
Exactly.
And we're not talking about that
We're not
either.
talking about that. Because that can't possibly be an infringement of
So-
Regulation 12. It doesn't give the designated person anything from it.
And the point I was putting to you is that so far as at least the last of those points is concerned, the word implementation might suggest the contrary, because one might be implementing a judgment if you're spending money in trying to enforce it, i.e. a judgment in your favour rather than a judgment against it. So that if you have a judgment which does fall within this, and you wanted then to spend some funds on seeking to enforce it, that might be licensable. because it was in aid of implementation.
Yeah.
Is that a possible reading?
Well, it may be, but with respect, I'm not sure why that would make this relevant to the point that we're on.
Well, one of your, it's not your only point, but one of your points about the judge's adoption of this is that this was only concerned with satisfaction of judgments made against a designated person. And I was wondering whether, and that's why I put you, that what you were actually saying was that implementation was just the same as satisfaction. So that was only talking about a judgment against a designated person.
So this goes to whether it's for or against the person. And the argument is that because it refers to
Implementation, one could see
Should
circumstances
provide
in
that.
which it's intended to apply to judgments in favour of a designated person. That was all I was putting to you.
I mean, in essence, you say this could only matter if it showed that it were assumed that judgments could be entered post-designation. And you say that isn't apparent from this at
that
all.
isn't apparent from this.
On the contrary.
Sorry, my lord. Okay.
I said on the contrary.
On the contrary, exactly.
That,
So that is what we say about paragraph 130, and that's the judge's third reason in response to our regulation 11 argument. Now, I think I've already made the point that in relation to regulation 11, it may matter whether a cause of action constitutes funds, as we contend, or any economic resources as the learned judge held, because we accept, as I have, that if a cause of action is only an economic resource, this particular argument is not available by reference to the doctrine of merger. The doctrine of merger version of the regulation 11 point works only if the cause of action is a fund rather than an economic resource. And this gets me on to whether the learned judge was right or wrong to say that a cause of action is only an economic resource and not a fund. Can I just identify why we respectfully say that that is not right? And my lords, the starting point for this, I'm going to take it briefly because it only relates to a sub-argument of a sub-argument, but just for the sake of clarity, we say first that the starting point is that a cause of action is a type of property, that's to say, a shows in action. I don't think that is in dispute. And this being so, it will constitute funds for the purposes of the 2018 Act if it is a financial asset or a financial benefit. And I say that because if your lordships go back to section 60, I'm not sure we've looked at this, of the 2018 Act, page 816 behind tab 11. The lordship sees that page 816 behind tab 11, section 60, subparagraph 1, in this act, funds means financial assets and benefits of every kind, including but not limited to certain things. So, if it is a financial asset, it's common ground that a cause of action is an asset. If it's a financial asset, then it's a fund or financial benefit. And if it's an asset which is not a financial asset, which is what the learned judge held and which my learned friends conceded, then it is an economic resource only. And so for the purposes of this particular debate or dispute, the question is this a cause of action a financial asset or benefit? And we submit that it is, and we say that because, I should just say this, if your lordships look at the way in which this definition is constructed, and this is relevant to a point that the judge made, it says in this act, funds means blah, 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 including but not limited to the following. So this is non-exhaustive. And the only guidance your lordship have about this question is that it has to be a financial asset. And beyond that, we have examples which may be illustrations of what is a financial asset. But there is nothing else that we have which tells the court whether an asset is a financial asset. In a sense, that's how the question arises. We do, however, say that the cause of action is a financial asset. And we say that in part because we say it is similar in nature to some of the assets identified as financial assets within this list. We say it is similar, for example, to debt obligations and guarantees and rights of set-off, which you see in E. Right of set-off perhaps being the easiest example to take. Now, your lordships may recall that the learned judge gave 3 reasons why she considered causes of action were not financial assets. And if your lordships go first to paragraph 118 of the judgment, you have 2 and there's a third in 119, that's at page 171. Page 118, page 171 behind tab 8. There are 2 points which immediately appear. The first is that there is a clear distinction, so 118, 2 points which immediately appear. The first is that there is an immediate distinction, so a clear distinction between these and a cause of action at least. They are certain if some are fluctuating in value. A cause of action is not certain. It admits of the possibility of loss. That distinction then suggests the second point. Why are these identified and not causes of action? In this context and with this range of possibilities identified, absence may be thought to be more likely to be witting, not unwitting. And perhaps I can just deal with the second argument first. Why is this not identified? It's a non-exclusive list. It's a non-exhaustive list. The fact that it's not identified, with respect, is not the answer to the question as to whether, if it was identified, that would be the answer to the question. But the non-identification of a cause of action doesn't tell you that it's not a financial asset, because section 61 says it includes but is not limited to the following.
Yeah.
So the issue is the judge's first reason, the others are certain if some are fluctuating in value, and that is said to be a distinction between economic, and there is a possibility of loss, I think she says, in the 4th line. But my lords, we submit that the possibility of loss, whatever that may mean, cannot be a reason for not treating something as funds, as a financial asset, because some of these other examples in section 61 also admit, it's not clear what possibility of loss means, but it may mean you don't get what is said to be the value of the cause of action. But with respect, you could say the same thing about a right of set-off. That also is, it's a right which may or may not, when tested, come to be the same value.
Even guaranteed, because in certain
Guaranteed is
circumstances,
exactly the same.
guaranteed is not valid.
Exactly. And it's also not liquidated. Guarantee is unliquidated, so is a right of set-off unliquidated. A cause of action plainly is unliquidated. There is some uncertainty involved in these things. So whatever the right reason for distinguishing these are, possibility of loss and uncertainty with respect is not it, nor is the fact that it's not identified in the list.
And just as to the guarantee, you say that's because it's a damages claim.
This is a
rather than
damages.
a debt claim.
Indeed, it's an unliquidated. It's an unliquidated claim. It's a claim for damages. Now, the learned judge's third reason, your lordships will see at paragraph 119. Just look at that at page 171. This is where the learned judge picked up a submission made by my learned friends at paragraph 44 of their skeleton, where they say that if a cause of action is a fund, that would have, in their words, far-reaching and absurd consequences. Now, we respectfully submit that that is not right. To some extent, I've debated the point as to whether my learned friends are right to say it would have far-reaching consequences. Do you use your cause of action when you issue a claim? We respectfully submit that you don't. But there is a second reason as well, which is that in our respectful submission, it is wrong to interpret the word use as if any use will do. And can I make this point, my lords? Because the first point about whether you use, I can see the arguments one way or the other. You are using it when you issue it. But with respect, if properly read, we say Regulation 11.4. I'll just go back to the provisions. 11.4. A and B do not allow for the, in a sense, the absurdity argument that my learned friends wish to make. I'll try and unpack what I'm saying a little bit more clearly. If your lordships look at, for the purposes of subparagraph 4, for the purposes of paragraph 1, a person deals with funds if the person uses, alters, moves, transfers, or allows access to the funds, comma, and then you go to B, deals with the funds in any other way that would result in any change in volume, amount, location, ownership, possession, character, or destination. Now, in our respectful submission, the right way of reading A is that you need to read the uses, alters, moves, transfers as all being subject to the in any other way that would result in any change in etc. In other words, just using it in a way that doesn't result in any change in volume, amount, location, ownership, possession, character, or destination is not a sufficient use. And we make 2 points about that. The first is, with respect, leaving aside the absurdity argument which is made about a cause of action, you could say exactly the same about any other fund, that if it's just use in any way which is in a sense not tied to anything, it goes too wide. And if that were a way of eliminating funds, I could use for example, a guarantee in a way which someone would say was absurd, or I could use a debt in a way that someone would say absurd, just because it's not hinged to any of the things in B. So as a matter of logic, in our respectful submission, as a matter of common sense, it really does need to be read as qualified for that to narrow it down.
Can you give an example? What would be a use of a guarantee that was not within A?
What if I threaten to call it on a guarantee unless you do something? What if I threaten to, I don't know, tear up a guarantee? If you
do you
park your
use a
car
guarantee on any basis? You threaten to tear it up.
Well, aren't I using the existence of a guarantee? Aren't I saying I have a guarantee, I'm going to use it? Look, it begs the question as to whether I use the course of action when I just issue a claim.
Well, that's precisely the point, isn't it? Because I think following, if the issue of the claim is not the use of on the assumption this is funds, is not the use of funds, then I can see the argument. If you take rights of set off, for example, simply if I say to you, I'm going to sue you on this cause of action, and your response is, well, I'm going to counterclaim for with a right of set off. That in itself would not amount to a use of the right of set off.
Yeah.
That's the point.
That's the point. It has to be tied to something, and we say what it needs to be tied to in order to make sense is what you find in B, where it goes on to say, in any other way that would result in any change in volume, etc. Now, I'm not making this up, although it may sound like it. The argument has some support from the fact that if you look at the regulations, which the EU regulations, which these are intended in some sense to provide continuity for, they support the argument that all of the foregoing in A is also qualified by B. And can I perhaps just show that to you very quickly? It's Regulation 269-2014, Volume 1, Tab 2, page 9.
Page
9.
Just one very minor oddity about this version of the regulation. It doesn't include the recitals. There are recitals.
Can we remedy
to this now?
I don't know the answer to your Lordship's question whether there are, but we will look, and if there are,
I think there are.
Okay. Well, I apologise for that. Apologise. I'm sure you've read them at some point, but if you look at 1F on page 9, freezing of funds means preventing any move, transfer, alteration, use of, or access to, or dealing with funds in any way that would result in any change. And whoever did the transposition obviously thought it's a very long paragraph, I'll split it up into two. But in our respectful submission, again, the learned friends say there should be continuity. This is one of the points where continuity in a way helps us. If you look at what Regulation 1F said, that does, in our respectful submission, provide strong support for reading Regulation 11.4 the way that we have suggested. I would just note in 11.4 that it does say deal with the funds in any other way.
Yeah.
The other way reflecting back to the ways in which it's identified you could deal with them. So that is why the absurdity argument with respect doesn't work, because the use has to be tied to the bits that you see it being. Now, my lords, for those reasons we submit that even if we're wrong on Regulation 12, the entry of judgment on the cause of action advanced by the claimants would be unlawful on Regulation 11.
How far does your argument go? Is it all causes of action for damages are funds rather than economic assets?
Yes.
So, just looking at section 60 again, the structure seems to be that economic resources are non-financial assets. So, physical goods, perhaps to take an obvious example. I have a cargo of grain in my warehouse. That's an economic resource. It's not a fund.
Yes.
Now suppose the cargo of grain is not in my warehouse, but in somebody else's warehouse. It's mine, and I have a right to possession, and I have a cause of action against the warehouse keeper for damages if he doesn't look after it carefully or whatever. Does that then, the fact that it's in somebody else's warehouse, turn that now into a financial asset?
You have the grain, which is an economic asset, the cause of action for, if you actually have a cause of action for damages
That's
or money,
that's then a financial asset.
that becomes a financial asset because it is for money. It has a money value. I know your Lordship will say that the others have a money value as well, because grain has a money value. But in our respectful submission, you can't look at any of the provisions of section 60 and say, well, that is, section 60 is dealing with say, a lot of different shows as in action, if I can put it that way. A lot of them are, in fact, shows as in action. And a cause of action is a shows in action. It has a financial, and because of that, it has a financial, if it's for damage.
I understand that, but I'm just testing whether
Your
all
Lordship is
shows
right.
is in action,
That
which seemed to be what you were confirming was your case. All shows is in action, at least shows is in action for a money sum.
damages. Indeed.
Damages all dead.
Indeed. So it may be, your Lordship may be right, but maybe, and although your Lordship identifies it, and it does look curious, with respect, I'm not sure that it really gives rise to that problem, because the question is how you deal with it. let's assume that you have at one and the same time a cause of action which is a fund as well as an economic resource. It only matters when you look at whether you're trying to deal with one or the other. If I assign the cause of action and I get money for it, well, that's a problem, and it may not matter whether it was the funds or the cause of action, or it was the fund or the grain. I'm getting money for it. Either way, it's going to be prohibited. I'm not really sure why it matters that in one and the same, I could have something which gives rise to a cause of action which is a fund as well as an economic resource. Because I could deal with the cause of action and not the grain. In a sense, why not? I could
It has to be a
assign-
money claim in your case, does it?
Yeah. Well, it has to be financial. It has to be a money claim. Again, I'm not saying this is the easiest statute to interpret or regulations. There are curiosities, and we're going to run across quite a few as we go along. But in my respectful submission, the interpretation that we identify is the correct one, and the reasons that the learned judge has given as to why we're wrong are not correct. Now, unless your lordships want to raise anything with me about, in a sense, the bog standard, if I can put it that way, interpretation of the regulations, I was going to move on to the European backdrop, because this, as your lordships know, is important for my learned friend's argument, and it's certainly important to the learned judge's reasoning. Again, just so your lordships have this, we deal with in our skeleton argument at paragraph 45 and following. That's on page 49. And this issue arises, or this topic arises, because, as your lordships would have seen, the learned judge, when considering the interpretation of the 2018 Act and whether entering into a judgment would infringe regulation 11 or 12, had regard to the pre-2018 European sanctions regime and held that it did not preclude the entry of judgment, and then inferred from that that the 2018 Act did not intend to depart from that. And this is the continuity point, if I can put it that way. This forms, as your lordship saw, I think, from paragraph 81 to 85, an important part of the learned judge's reasoning. But your lordship see the continuity point, just to give you a note to this, paragraphs 36, 85 and 94 of the judgment. We've looked at 85 and 94, but the same point arises in paragraph 36 as well. And as your lordships may recall, the learned judge gave three reasons, or identified three features, of the European regime in coming to her view that the European regime did not prohibit the entry of judgment. The first of those concerns Article 7.2c, 7 subparagraph 2 subparagraph c of the EU regulations. I'm going to identify the 3 points first and then go through them. The second concerns Article 11 of the EU regulations. And the third concerns what was said to be the absence of a prohibition on the entry of judgments in the EU regulation. And we respectfully submit that all of those points are, with respect, wrong. Can I just deal with them? I'm not going to deal with them in the same order as the learned judge. I'm going to take Article 11 first, if I may. Now, Article 11 of the EU regulations, just to say we deal with this at paragraph 51 of our skeleton at page 53, but your lordships will find Article 11 at volume 1, tab 2, page 21. Volume 1, tab 2, page 21.
Yeah.
Your lordships have it, just looking at it, I need to read Article 11.1, if I may. No claims in connection with any contract or transaction, the performance of which has been affected directly or indirectly, in whole or in part, by the measures imposed under this regulation, including claims for indemnity or any other claim of this type. such as a claim for compensation or a claim under a guarantee, particularly a claim for extension of payment of a bond, guarantee, indemnity, particularly a financial guarantee or financial indemnity or whatever form, shall be satisfied if they are made by A, designated or legal persons, entities or bodies listed in Annex 1, B, any natural or legal person, entity or body acting through or on behalf of any one of those persons, entities or bodies referred to in point A. And just on this provision, what the learned judge made of this, can I invite your lordships to go in the judgment to paragraph 38 on page 154. On tab 8, page 154. Paragraph 38. Just looking at the first 3 lines, your lordship sees that the learned judge says, first sentence, the article on its face imposes a restraint in relation to bringing claims which are affected by sanctions, and then she says this, that the corollary of this provision is that it does not affect claims which are not related to sanctions, such as pre-existing claims. And that with respect is correct. But if your lordships then go to paragraph 43 on the facing page, page 155, the judge then turns back to Article 11, paragraph 43, and picking up a submission that my learned friends made to her, she goes on to say, and this is about 9 lines down, that this logically implies that there are claims which the sanctioned person is allowed to pursue to judgment. So the argument is that Article 11 gives rise, by necessary implication, to the conclusion that there are claims that you can pursue to judgment, and on that basis it is said that this shows that under the European regime you could get a judgment against the sanction, in favour of a sanctioned person. Now, with respect, we respectfully say that the learned judge fell into error here. Again, we have 3 reasons. First, as your lordships will note, Article 11 is obviously a prohibition and not a permission. So if there are some other provisions which are prohibitions in the regulation, which they obviously are, there's Article 2.1 and Article 2.2, which effectively map onto Regulations 11 and 12. If those provisions would make it unlawful to enter a judgment, then the mere fact that the entry of judgment is not also prohibited by Article 11 is irrelevant. Article 11 obviously doesn't say you're allowed to have a judgment if you're a privileged person. It just says, here's a further circumstance in which you cannot get a judgment. It's just a further prohibition. And that further prohibition can be infringed even if the designated person can establish that Article 11, further prohibition, for example, in Article 2 can be infringed even if Article 11 isn't. And an example of that is obviously a assignment of a cause of action. Now, the learned friends accept that a cause of action is an economic resource, and it's also established as a matter of EU law that a cause of action cannot, without a license, be assigned or set off by a designated person. For your lordships note, I'll come to it later, that's the European Council's guidance 2015, June 2015, paragraphs 46 and 47, volumes, well not volumes, tab 112, pages 5112 to 5113. Same point is made in a textbook, Banks and Financial Crime by Sir William Blair, paragraph 9.08, that's tab 123, page 5470. So it's clear that under EU law, the assignment of a cause of action would be an infringement of Article 2.1, by which funds and economic resources, including cause of action, are frozen. Now, plainly, if the cause of action that the designated person is seeking to assert predates sanctions, as it does in this case, then Article 11 would not be a provision that by itself prohibited the assignment or settlement of the cause of action, because the claim in that example, the cause of action, is not one that is affected by sanctions. So Article 11 wouldn't apply. But the fact that that is not prohibited by Article 11 doesn't mean that the assignment of a cause of action should be allowed, because this is a prohibition and not a permission. I'm labouring the point, but your lordships, I think, have the point. The next point with respect is this. The point that the learned judge makes about Article 11 is irrelevant because there is, we submit, an important distinction between Article 11 on the one hand and Articles 2.1 and 2.2 on the other. That is to say, between Article 11 and the provisions in this regulation, which were, in a sense, the precursors to Regulations 11 and 12. In particular, my lords, Articles 2.1 and 2.2, or Regulations 11 and 12, are temporary prohibitions. This is the key point. They are temporary prohibitions which only apply for as long as sanctions are in place. They only apply for as long as the person is designated. If sanctions are lifted, if the designation is lifted, those prohibitions fall away. Article 11, by contrast, is a substantive provision. It extinguishes for all time, not merely while the designated person remains designated, claims that fall within Article 11. That is to say, claims under a contract, the performance of which was affected by sanctions. And the purpose of this is obvious. Let's say you have a claim which someone can't perform because sanctions prevent them performing. The designated person can't later sue the non-performer and say you're in breach of contract for non-performing. That is for all time. It extinguishes that sort of claim. Now, I ought to be clear that the learned judge rejected our submission that Regulation 11 or Article 11 was for all time. And if your lordships go back to paragraph 43 of the judgment, your lordships see the last sentence there. The learned judge says, the further argument advanced for the defendants that this provision was aimed rather at post-sanctions claims seems to be at variance with the language of the provision, which seems to be predicated on the list remaining in force. And with respect to the learned judge, that is contrary to House of Lords and Court of Appeal authority, which was cited to the learned judge. In the interest of time, I was only going to take your lordships to the more recent Court of Appeal decision, which my Lord Justice Newey may recall. It's the, the Modsaf case, which is at tab 57, page 3457. Tab 57, 3457. Just to remind the court, the issue in this case was whether interest was payable during the sanctions period on an arbitral award in favour of the designated party made before the sanctions period. Mr. Justice Phillips, at first instance, and also the Court of Appeal, which, as your lordships see, included Lord Justice Newey, held that interest was not payable because the entitlement to interest was taken away by Article 11, which in the regulation before the court in that case was Article 31. Can I just show your lordships paragraph 34, bundle page 3469. This is in my Lord Justice Newey's judgment.
Yeah.
It is clear that the no claims provisions, such as Article 38 of the 2012 regulation, do have confiscatory consequences. And that is very different, obviously, I'm just pausing there, from sanctions regime, which doesn't have confiscatory consequences. While Article 23 may do no more than impose a freeze for the duration of the sanctions, Article 38 goes further. In fact, Lord Anderson accepted, at least for the purpose of the hearing before us, that Article 38 operates permanently to confiscate a claim where it applies. Authority for that is to be found in the decision of the House of Lords in the Shannon case. That concerned a regulation adopted following a Security Council resolution which had included at paragraph 29 a decision by the Security Council that states should take measures, and then you see that, I'm not sure I need to read that. If I can invite your lordships also to look at paragraph 38, page 3471. In fact, recital 4 to the 2008 regulation confirms that what has become Article 38 of the 2012 regulation was intended to protect counterparties of designated persons.
Sorry, which paragraph are you reading?
Paragraph 38 on page 347.
Yeah, okay.
Sorry. In fact, recital 4 to the 2008 regulation confirms that what has become Article 38 of the 2012 regulation was intended to protect counterparties of designated persons. As can be seen from paragraph 14 above, the recital recorded that economic operators are exposed to the risk of claims, and it is therefore necessary to protect such operators permanently against claims in connection with any contract or other transaction, the performance of which was affected by reason of the measures imposed by that regulation. So with respect, the learned judge was wrong to think that this only applied during sanctions.
Yeah.
It extinguishes the claim, and that with respect matters. Because it does explain what Article 11 is doing. It doesn't tell you anything about the ability to get a judgment during the sanction period. It's effectively another prohibition for all time on anyone claiming against the counterparty who didn't perform because of sanctions. It's really got nothing to do with what we're talking about.
Is that a convenient moment, Mr.
My lord, yes. I'm sorry.
2 o'clock, please.